All right, y'all, what's up, man? Check Sean G out. Check Sean G out. I'm tired. I did 101 burpees this morning. I'm beat. But the show must go on, and we gotta do this content because I know y'all be relying on me to do this content. All right, so today we got, sorry about that, y'all. I gotta make sure my camera. I'm everything. I'm the CEO, I'm the janitor, I'm the cameraman, I'm the attorney, I'm accounts receivable, I'm accounts payable, I'm everything. Welcome to the Podcast for Soul. Follow me on Instagram, the Podcast for Soul. Follow me on Spotify, the Podcast for Soul. Follow me on TikTok, the Podcast for Soul. Abercrombie and Fitch, Michael Jeffeies was arrested in South Florida. The arrest warrant was signed by the Honorable Lee Dunst. This was in October 17th, 2024. You are commanded, United States of America versus Michael S. Jeffeies, who was the former CEO of Abercrombie and Fitch for 22 years. To any authorized law enforcement officer, you are hereby commanded to arrest and bring before a United States magistrate judge without unnecessary delay Michael S. Jeffeies, who is accused of an offense or violation based on the following document filed with the court: indictment. The offense is explained: SEX trafficking in violation of Title 18 United States Code, sections 1591 subsection A subsection 1, 1591 subsection A subsection 2, 1591B subsection 1, and interstate selling of the body in violation of Title 18 United States Code, section 2422 subsection A. This is in Central Islip, New York, CI. All right. Now, Michael Jeffeies, they're trying to figure out if he's mentally competent enough to stand trial. I saw some videos of him on the YouTube of them showing the arrest. He don't look too hot. He's a lot more elderly than what he probably, well, of course, what he used to be, and he doesn't look too hot. But anyway, this is the United States District Court, United States of America versus Michael S. Jeffeies, case number 24-CR-423. This was filed May the 2nd, 2025. So this was filed last month. Okay. Whereas on December 24th, so let me come off the top of the dome first. So what they did was they had a forensic psychologist and psychiatrist evaluate him, two of them, and what they determined was that he is unfit to stand trial. So what they did was the Bureau of Prisons put him in a medical facility within the prison system. They have the Department of Justice, Federal Bureau of Prisons, have prisons that are medical prisons where, you know, just because you get sick in prison or you get dementia, they don't let you out. You just go to a prison where there is a lot of medical staff there. Lexington LMC, Lexington MC, what's the name? Lexington FMC, Federal Medical Center, and they got one up in Boston. I don't know the name of that one, but if you get sick or you get hurt in the Bureau of Prisons, they will send you to one of those prisons. They may have some on the West Coast, I don't know, in the Midwest. So let's read this. Whereas on December 10th, 2024, pursuant to 18 U.S.C. 4241, this court issued a competency order directing that a hearing be held to determine the defendant Michael Jeffeies mental competency. Prior to the hearing, Dr. Alexander Barty and Dr. Cheryl Paredes shall each conduct a psychiatric or psychological examination of Jeffeies for the purpose of determining whether he presently suffers from a mental disease or defect, rendering him mentally incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him, or to assist properly in his defense. In an evaluation report dated February 5th, 2025, the defendant's expert, Dr. Alexander Barty, determined that the defendant was not presently competent to proceed. In an evaluation report dated March 18, 2025, the government's expert, Cheryl Paredes, also determined that the defendant was not presently competent to proceed. So the defendants hired, Jeffeies hired his own psychiatrist, arranged his own psychological examination and hired his own psychologist, and the government did the same thing, hiring their own psychiatrist and arranging their own psychological examination, and both of them determined that Jeffeies is unfit to serve to proceed at trial. Upon the application of the defendant Michael Jeffeies, and with the government's consent, it is hereby ordered that the court finds by a preponderance of the evidence that the defendant is presently suffering from a mental disease or defect, rendering him mentally incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him, or to assist properly in his defense. The defendant shall be committed to the custody of the Attorney General for a period not to exceed 4 months to determine whether his competency may be restored. The Attorney General shall hospitalize the defendant for treatment in a suitable facility. Number 1, for such a reasonable period of time not to exceed 4 months, as is necessary to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward. Number 2, for an additional reasonable period of time until A, his mental condition is so improved that trial may proceed if the court finds that there is substantial probability that within such additional period of time he will attain the capacity to permit proceedings to go forward. B, the pending charges against him are disposed of according to law. If at the end of the time period it is determined that the defendant's mental condition has not so improved as to permit the proceedings to go forward, the defendant is subject to the provisions of sections 4246 and 4248. I'm going to come back to those. It is further ordered that the Bureau of Prisons shall promptly determine a suitable facility for the defendant Michael Jeffeies to be evaluated by a forensic psychologist or psychiatrist in an effort to restore his competency to proceed. The defendant shall surrender to the facility designated by the BOP, the Bureau of Prisons, on the date specified by the Bureau of Prisons. It is further ordered that during the 4-month period of the defendant's custodial hospitalization, the parties shall be permitted to seek periodic reports from the Attorney General regarding the status of the defendant's condition and likelihood to regain competency. Upon such request, the Attorney General shall file a status report with the court under seal regarding the status of the defendant's condition and likelihood to regain competency, and provides copies of the same to the parties. It is further ordered that if at any point to the conclusion of the defendant's 4-month custodial hospitalization, the Bureau of Prison determines there is not a substantial probability that in the foreseeable future the defendant will attain the capacity to permit the proceedings to go forward, and the necessary risk assessments under 18 U.S.C. 4246, 4248 have been completed, the defendant shall be released from the custody of the Attorney General forthwith to home confinement with the same standard and special conditions of pretrial release he is currently subject to pending further proceedings by this court. May the 2nd, 2025. So, Section 4248, sexually dangerous person. In relation to a person who is in the custody of the Bureau of Prisons or who has been committed to the custody of the Attorney General pursuant to Section 4241 subsection D, or against whom all criminal charges have been dismissed solely for reasons relating to the mental condition of the person, the Attorney General or any individual authorized by the Attorney General or the Director of the Bureau of Prisons may certify that person is a sexually dangerous person and transmit the certificate to the clerk of the court for the district in which the person is confined. The court shall order a hearing to determine whether the person is a sexually dangerous person. A certificate filed under this subsection shall stay the release of the person pending completion of the procedures contained in this section. And then there's a whole bunch of other stuff on the back. So they've determined that he is not fit to go to trial at this point. I don't know if he has been released to his house. I got another document over there. I'm going to look at that one probably tomorrow. But you know, this is where we are with this with these guys, man. This Jeffeies dude, I don't know. You know, I don't know. You know, it's not with federal cases. You know, it's not like you can take. It's not like you can take. Right. You can take this baseball bat and this baseball bat and say these are two baseball bats, right? They got different colors on them and different grips, but at the end of the day, they're two bats. With federal cases, you know, a lot of people are juxtaposing this case against Puffy's case. Puffy beat his case because, and now I see why Puffy beat his case, because in this indictment with these three guys, Michael Jeffeies, Matthew Smith, and James Jacobson, this is truly a RICO case. They truly set up an enterprise, right? A structure. And that structure and that enterprise was set up to specifically recruit men for sex events to satisfy this dude and them two other dudes. And they trafficked these guys, right? So this is 1000%. If they had charged them with RICO, I don't know why they didn't charge them with RICO. Like I say, those are two bats. Cases are different, right? Did they overcharge Puff? Absolutely. And the jury spoke. Puffy went to a jury trial. The jury spoke. And they found Puffy not guilty, right? He was acquitted of RICO. He won, right? They charged Puffy with sex trafficking. They also charged these dudes with sex trafficking. This is guaranteed. If they go to jury trial or trial by judge, they're gonna get busted in the head on both ways. You know, but you know, a lot of y'all want me to, you know, you do whatever you want to do. You do whatever you want to do. You compare it however you want to compare it, right? You know, Puffy the black man, they didn't They didn't do the white man like that. They let the white boy go and let the nigga, they hung the nigga up. You know, that may be true, but like I say, all federal cases are different, man. It's not like those two bats, you know. That's all I can tell you. And I can tell you that from my experience of being in the federal system, of being indicted by the feds on a 28 count indictment. I was indicted on a 28 count indictment, aiding and abetting in the preparation of fraudulent tax returns. Took a plea, did not go to trial because I was busted, and went to prison, you know. And I met dudes in there that were other tax preparers, and their case was different than mine, you know. They're all different, man. Some of them got more time, some got less time, some, you know, you never can say. But y'all make your own determination up. But this dude, what him and those other two dudes did, them other two dudes, they gonna wear it. They gonna wear it. And see, you gotta consider, you know, that you know, you never know. You never know. Sean G, Podcast with Soul. If you want to do a one-on-one call with me, mentorship call, the link is underneath this video. If you want to join my 8-week fitness program to lose weight and get in shape so you can start looking like something, the link is underneath this program. It's $4,200 for 8 weeks. Guaranteed. We're going to do all prison workouts. You're going to look great. You're going to look better than you ever looked in your life, and you're going to feel better. And I'm going to get you off your medication. Sean G. Peace.